Court thought it proper to give an opportunity to the appellant to issue directly notice to the appellant to engage another lawyer. Number 10, as per office note, the said notice was issued on 25/11/2013 as per the office note in the first copy. But thereafter, the second notice note, Lord University may see 22nd August 2015 in the office note. It is mentioned there that direct notices were issued to the appellant, and thereafter the note is whether anybody has filed Okalatnama. That has been replied from the computer section, no Okalatnama has been filed. But the fact remains the service report of that notice is not on the record, subject to correction. I have thoroughly more than once I have checked. हमको जो 2-3 बार हम देते अपना कंफ्यूजन दूर करने के लिए जो लास्ट ऑफिस नोट देखेंगे जब 2014 में डिसमिस पर डिफॉल्ट लॉस के पहले ऑफिस नोट है सेकंड अप्रैल का फर्स्ट अप्रैल का नोटिस इशू हुआ है उनको लगा हुआ है नोटिस सर्व हुआ कि नहीं सर्विस रिपोर्ट हमको नजर नहीं पड़ा and maybe wrong, but I have checked it up twice. Notice has been shown to be issued on 25/11/2013. And the office note thereafter is direct notice has been issued to the appellants. That is there. But thereafter there is no service, nothing has been said with regard to service. And the next question was whether anybody has filed Okalatnama. The report is no. Again it was placed on the date when it was dismissed. The same office note, direct notice was issued to the appellant, no Okalatnama has been filed. But the service report subject to correction, that is not on the record.
Yes, what do you say to this? This appears to be correct, whatever you say. The court took note of the fact that that time Ms. Nirupama had left practice.
Yes.
And therefore issued direct notice to the appellant. But there is no service report. And on the next day, the case was dismissed for non-personal. So therefore, it cannot be said that the appellant had knowledge that her advocate is not going to appear in the matter.
But to point after the death of his father, the petitioner said there are 40 or 50 cases going on. He would have 11 months is sufficient. If 11 months is more than sufficient.
That's right. But
Could have done it within after the death of his father. He should have more vehemently approached the cases of his father.
Mr. Sani, you filed your affidavit.
Yes.
And you, if you do not file your response to the interlocutory application, you will say that everything stands agreed. You file your response, verify the second appeals record, but it does not appear that it has the notice. There is any service report with regard to the notice. CMB number 351 of 2019. The learned counsel for the appellant prays for 2 weeks' time
2 weeks, sir.
to file a supplementary affidavit. He submits that there was sufficient reason for not taking steps by the father of the petitioner for not taking steps for restoration in spite of order dated 14/1/2016. If the supplementary affidavit is not filed, the case will be taken up on the basis of material summary.
Yes.
The learned counsel for the respondent is also prays for and is granted time 2 weeks thereafter to file response to the interlocutory applications of the present as well as to the supplementary affidavit which will be filed by the petitioner. post on 13th of March.
February.
February, okay. 27.
Item 12, CMP 776 of 2019.
Yes.
For restoration of civil review.
Civil review.
Civil review.
Why was it dismissed?
Due to non-compliance of the entry order, 2 weeks time was granted for filing interlocutory application, but which could not be
This was for restoration of
restoration of civil review number 54
arising of
arising out of second appeal.
how much is the delay?
Delay. There is no delay.
82 days. Delay has been confirmed.
No. Delay is no. इसमें within time.
The 82 days का ये क्यों
वो
फाइल?
अदर का CMP था जो allow हो गया, my lord allow किया. CMP का CMP था that was allowed, and thereafter this CMP 776.
I'm not able to get it. There is an interlocutory application for coordination of delay. CMP number 776 of 2019. Council for the petition is not ready. Post this case on 7th of September. आराम से ready होते हैं. You don't bother about it.
वो नो को हुआ
कुछ नहीं पड़ता है.
था.
फाइल नहीं पढ़ के आइएगा तो एक साल केस एडजर्न कर देंगे.
Item 13, CMP 120 of 2022.
In this case, notices were issued to the sole opposite party. Ultimately, it was reported that she died. Therefore, got an application under order 22.4 and 9, read in section 5 of the Limitation Act has been filed. IA number 6339 of 2020.
How much is the delay?
The setting aside the
How much is the delay?
delay blood, it was reported after notice that during the pendency of the second appeal blood, she died on 3/12/2022. Sorry, she died on 27/1/2019. mentioned in paragraph 3,
27/1
2019.
2019. After dismissal of second appeal.
After this, it was dismissed on 3/12/2022. The second appeal was filed on 5/70 of 2015.
5/7/2015.
0 of 2015 is the second appeal. During the pendency of the appeal, she died. Number it was not, no notice was issued, and the defect was there. Therefore, all the defects have been removed by filing in IA. But one defect should not be removed. It was 1 week time was granted by the Supreme Court, and within time all other defects have been removed, except one due to mistake on our part. And therefore, this appeal was dismissed for default, and notices were issued in the restoration. Then the notice report, the service report of notice reported that on 27/1/19 she died.
There is a petition for substitution.
Yes, ma'am. That is not order. IA number 6339 of 2025. 6339.
Along with petition for condemnation.
The same prayer has been made in the same petition. It was
Who
not
has
in
expired? Only one opposite
sole
party.
opposite party. Sole opposite party Krishna Prasad. He died. Leaving behind his legal heirs mentioned in paragraph 3. Order was passed by the Supreme Court in the restoration matter.
And what about the other IA?
Other is the petition for condemnation of delay of filing restoration and notices were issued in the limitation.
Yeah, IA number 6339 of 2025. This petition has been filed for substitution of the
Solo.
sole opposite party in the second appeal.
In this
In
and
second
also
appeal
in
number?
this case, in
अच्छा इसमें भी.
इसमें
Okay. Substitution of the sole opposite party who is said to have expired on 27/1/2019, leaving behind the legal years mentioned in paragraph 3 of the interlocutory application. The petition for substitution is barred by 346 days. A petition for condonation of delay in filing the present restoration application
Notice as a
being
issue.
CMP number, notice was issued then,
Yes.
being
IA
CMP
number-
number 120 of 2022 through IA number 2619 of 2022 has been filed for condonation of delay of 346 days. दोनों में 346 days.
362 days.
346 days. आपका
346 days.
346 days. The learned counsel has submitted that.
Notices were issued in the
Notice were issued in the limitation matter
on by order dated 3/12/22.
in SA number 570 of
Then in this
2015.
CMP was barred by
In this CMP, okay. The learned counsel submits that. In this CMP, notice was issued, and upon service report, it came to light that the opposite party has expired way back in the year 2019. Issue notice to the proposed legal heirs and successors of opposite party whose details have been mentioned
in para 3
in para 3 of IA number 6339 of 2025 to the concerned police station in CMP and both the indemnity applications, for which requisites be filed within requisites be filed by 16th
Yes.
through police station.
Yes.
Post on 6th of February.
Item 14,
सीएमपी के पीछे लिखा हुआ
क्या
ऑफिस
चीज?
रिपोर्ट वाला
कोई बात नहीं, अब छोड़ दीजिए, आप डेट दे दीजिए।
सीएमपी के पीछे लिखा हुआ था वो IA-82 है जो है सिविल रिव्यू में
छोड़ दीजिए।
एक-
आप अगला डेट करेंगे।
In this,
डेट वही रहेगा।
item 14, CMP 799 of 2023.
in this case, three IAs was filed. One IA is arbitration petition over condemnation of the delay of the restoration petition. Kindly,
How much is the delay? And what is that IA?
in this case, my last order is my kindly.
Which is that IA? IA number?
IA number 12250/2025. Before that, my lord, I want to place on dated order dated 9th May 2025. Notice was issued, so far the limitation as also restoration petition.
Restoration of?
Restoration of the second appeal number 513/2018.
The appearance is not correct.
In this case, my lord, some respondents has been appeared and the office note is there, my lord, according to the office note dated 17/9.
What is this for ignoring the defect?
The defect is that the defect which has to be removed by the court below or by substitution. That's why
No,
we
I'm
have
not interested. In restoration, which defect is to be ignored?
that is when some defect that is already ordered in the by this honorable High Court, that defect number 21 to 29 will be removed by the court below. Some defect has been removed by the
In the second appeal it must be there. I'm asking what is the defect in the CMP?
same all defect has been
No, there is
removed.
one IA for removing the
Yes,
defect.
IA has been filed that even in spite of the removing the defect, there is some other defect also which is to be kindly see the IA number 40866.
Yes, what is it?
4066 of 2025.
Yes.
Apart from the limitation IA, the other two
Yes.
IAs have not been sent.
Yes.
I do not have the copy of the other two IAs. I total.
No, order was passed to only for limitation as also the continuation. Unless that is the
What is this IA, madam? What for this IA has been filed? Which
IA
defect
has-
you want to be ignored?
yes, my
Which
lord.
is that defect number?
Defect number 56 already order has been passed by your lordship. That is the order dated, my lord.
This is not pending now. This
Yes,
IA is not pending.
Pending, but your lordship passed that order on 9th May 2025. Can you see that? 11th, 9th May 2025.
9th May 25.
Yes, that is also for the petitioner is present. The petition has been filed for distribution of the second appeal, has been dismissed for non-compliance. IA number 12250 has been filed for condemnation delay. Late notice be issued to the respondent in the CMP as well as the IA number for which it is under ordinary process. We filed
But there is one idea for defects. Maybe that I have not noticed it on that one.
the next paragraph. That with me. The petitioner shall place the deposits notice with appropriate stamp such and such under the post this case on 19th May.
Yes, that's right.
That is the order.
There is an IA filed by you for ignoring certain defects.
It appears as an order dated 25/4/2025. It is order number 5,
Yes.
in which IA
Ignoring that report.
was sort of
Right order was ignoring the report. Notice be issued.
Okay. In view
That
of
is 25/4/2025.
in view of order dated 25/4/2025.
Yes. Paragraph 2.
Just a moment. The office is directed to report as to whether there are any surviving defects. 7, 8 and 9 have been removed.
Mentioning that the defect number 7, 8 and 9 have been removed. Yes. But so
Just a moment. In view of order dated 25/4/2025, IA number 4066 of 2025 is closed. हो गया इसका IA का कहानी का?
yes.
Now you tell
Then
me.
my lord, can you see the office note? Office note is that my lord dated 17/9/2025.
Yes, what do you want?
Yes. In this case, my lord, it has been returned as date, that is 1/8/9/53/70/72. The first substitution petition is required to be filed. We shall file the substitution petition.
When did they die?
When they have died, we have to ascertain because we have no knowledge. We have no knowledge. Now we came to know from the office note. And second defect is, pointed out.
देखिए also for the as per office note dated 2/1/2026.
Official bill is 79/2025.
This court finds that OP number 1,
8,
office note dated
dated 17/9/25.
office note dated 17/9/25. This court finds that the opposite party number 1, 8, 9, 53, 70 and 72
Yes.
have been reported dead and the notice could not be served with respect to opposite party number 12, 37, 41, 58, 77
Yes.
and 52.
But so far 77 is concerned, my submission, there is also office note, the opposite party 76 has been appeared.
77 we appear.
77
You are
also the same,
77 we appear. 73 to 77 we appear.
so that may be,
You have filed Vakalata?
Yes.
Counsel for the Mr. So-and-so has submitted that he has entered appearance on behalf of opposite party number 73 to
77.
77. Counsel for the appellant is granted time to take appropriate steps in connection with service of notice upon opposite party number 12, 37, 41, 58 and 52 at their present and correct address through speed post or to file an appropriate petition seeking substituted service of notice by 29th of January.
Yes, sir.
Preemptive.
We shall issue notice, my lord.
We do not know if you at their present and correct address you have to give no.
Yeah.
If you are not able to find out, it says that he is not residing at that place. It will
Yes, I
again.
have to verify him where he is. But so far the 52 is
Yes.
that has been returned back, not served, only on the P.
Husband is missing.
No. 52.
Yes, 52. Return answer could not be found due to missing father and husband.
Due to missing father and husband.
Husband's name is missing.
No, that has been given. Whatever may be, I shall give.
Hope you do it.
Yes, sir. Fresh notice.
By if you are not able to find out the fresh address and if you are not able to take steps, then you have to file substituted service of notice. That's a preemptive order. Correct?
That
So far as the service of notice, counsel for the appellant has also submitted that. So far as the other respondents are concerned, the notice has been served either to themselves or through their close relative. She submits that the notice be accepted as valid. Any objection? Considering the submission, counsel for the appearing respondent has no serious objection to the prayer made. Accordingly, the service of notice upon respondent number 2, 5, 15, 16, 17, 18, 20, 23, 47, 56, 73, 3, 4, 10, 19, 21, 38, 43, 44, 46, 48, 57, 75, 76 and 78, 6, 7, 24, 27, 59, 60, 68, 72, 11, 13, 35, 50, 51, 63 and 64, then 14, 25, 22, 28, 29, 30, 39, 31, 55, 69, 32, 33, 62, 69,
66 also.
66, 34, 26, 36, 40, 42, 45, 49, 54, 61, 65, 67, 74 and 79 is accepted as validly served.
When is 22
Sorry?
22. 14, 25, 22.
I have said 22 मैंने बोला है?
Right?
मैंने बोला है.
I'm sorry. The time may be extended further 1 week.
For what?
To test out that.
अच्छा. 30 की जगह 6th February कर देंगे उसको.
Yes.
उस preemptive order में, right?
Much better. And substitution petition also within that period.
Yes, if you don't file it, it will stand. No, I will not give you time for filing substitute. It has already available.
No, we have to, just now I came to know their date, we have to ascertain.
It was already there, so you have to file a petition setting aside abatement for donation of delay. Why should I pass a judicial order giving you extension of time? That I will not do. Post on 27th February.
Item 15, CMP 1024 of 2023.
Yes, ma'am. Are you there in this case? Who is there?
In this case, the notice will be issued to the opposite party number 5, 6, 7, twice adopted, but notice could not be served. I may be permitted to take substituted service lawsuit for this of the identified and locality application notice.
You filed a petition for deletion of name also. Deletion of party.
Yes,
OP number 10.
yes. Because his legal years are already on record, Lordship.
CNP number. That can be allowed.
Yes.
IE number. Died in the month of March 2015.
Yes.
क्या जिसका restoration है ये?
Restoration of read petition, Lordship. इसमें पहले आइए हम लोग फाइल कर लेते हैं सर्टिफिकेट सर्विस के लिए, Lordship. पैरा 4 में लिखे हैं आइए नंबर 4485 और 2025. The opposite party.
Yes. The writ petition was restored earlier. The CNP was restored. The writ petition was restored earlier.
But there are due to my fault also could not take a step for service of notice.
So,
This is my fault.
no, this is not maintainable. You have to get the CNP restored. You will file fresh CNP. If you do not comply the order passed in CNP, then you have to get the CNP restored.
Yes, but
Then you have filed a fresh restoration application for the writ petition.
but it is also not bad, Lord.
What do you mean not barred?
It is
There is a judicial order.
yes,
Yes.
there is a judicial order, Lord.
No, so we have extended the time. Now you want another judicial order. This is not maintainable. You just satisfy me. There is a CNP with a condition for restoration of the writ petition. You do not comply with that within the time, and then you file another CNP for restoration of writ petition. You file restoration of CNP.
But law does not bar, Lord.
We will not entertain this. Writ में तो नहीं सुनेंगे आपका account 226 में. Restoration after
It is our
restoration.
vast power, Lord.
कोई पावर नहीं है हमको
Vast
इस
power.
तरह के नेग्लिजेंट लिटिगेशन को. यही सब के कारण है ना ढंग का केस नहीं हो पाता है. तीन बार नहीं आप अपना सीएफपी का
अच्छा इसमें हम एग्जामिन कर लेते हैं इसको नोट टू
क्या एग्जामिन करना
हम एग्जामिन कर लेंगे इसमें कोई लॉ पॉइंट होगा तो हम दिखाएंगे ओनली नोट आई एम प्रेइंग फॉर नोट टू
योर रेस्टोरेशन एप्लीकेशन has practically been dismissed. Okay, so
I will examine it.
CFP number 1024 of 2023, Council for the petition seeks adjournment. आपको कोई urgency नहीं है. 10th जुलाई का डेट दे देते हैं. नहीं
I am praying for
नहीं
note
इतना
today.
negligent litigant मेरे पास time
नेग्लिजेंस हम लोग नहीं करते
नहीं you are negligent.
I am not
Your litigant is negligent. आपको कहाँ बोलते हैं?
except some one cases
नहीं.
not see
It is-
next week will not be
It is not your negligence. It is the negligence of the litigant.
I know
आपको तो हम कभी कुछ नहीं बोल सकते. You are such a gentleman.
it's a date before
Item 16, 1st April 239 of
अप्रैल हो गया
2024.
इसमें लॉर्ड से रीड पिटीशन
My
वाला
time is very precious. ऐसा negligent के लिए हमारे पास time नहीं है. Yes, what is it? Where is the appellant? Yes.
Praying for conversion this to miscellaneous application, miscellaneous application. The last occasion, that's passed an order, committee order, checking whether it is maintainable or not. The order dated
You have to file an immediate the application. I pass it. FA number 239 of 2024. This is arising out of COVID. There is a judicial order of division bench that this first appeal is also needed. There is a judicial order.
That is what we were pressing in the last occasion.
Did I reject it?
No, not but the opposite counsel stated that they have something with respect to that.
They are not citing. Because there is a judicial order of division bench.
That is
So
there.
once there is a judicial order, we don't want to say it. You get that?
I've read that also.
You have read? I'm sure, I don't remember, but there is a judicial order
Yes,
that
yes, Lordship. That is
mysterious
there.
appeal or first appeal both can be filed and just.
Lordship, then in this case may be kept on Monday or Tuesday. I'll test that.
इस सर्विस रिपोर्ट का क्या करेंगे?
Service report, Lordship.
क्या चीज में नोटिस हुआ? Liquidation or in the first appeal?
First appeal.
So what is the service report? You are not aware?
I'm not there. And delivered 279 and only 10 has appeared.
And rest?
And rest they have not appeared.
They have not
Some-
appeared and they could not be served. You take fresh steps. All of them could not be served.
Lordship, served on 4, 5, 8 to 13, 18 to 20.
Oh, just a moment. 4, 5.
That is there in our Lordship's order.
4, 5, 8 and 18.
Lordship's
4, 5, 8, 18 have been served. 4, 5, 8, 18 to 20 have been served. You are for 10.
Lordship, correction on that. 4, 5, 8 to 13.
8 to 13 have been served. कहाँ से क्या बोल रहे हैं?
It was there in the report.
19, 20, 12, 13. 12, 13 the notice could not be served.
13 notice to one.
Then you are not aware. You are not aware. ऑफिस नोट भी पढ़ने के लिए क्या आपको वकालत की जरूरत है क्या? Your clerk can also read it. And this is a judicial order where it has been recorded who has been served and who has appeared. But you are not aware.
Lordship, go and go dash.
FA number 239 of 2024. In view of order dated 7/11/2025, the notice upon some of the respondents has been accepted as validly served, but they have not entered appearance. Respondent number 10 has entered appearance. Counsel for the appellant is granted. Time till 6th of February 2026 to take appropriate steps for service of notice upon the remaining respondents at their present and correct address, or to file an appropriate petition seeking substituted service of notice. Notice under speed post.
Lordship, return copies will be allowed.
The counsel for the appellant would be permitted to, office is directed to permit the appellant to use the return copy of the notices. Post on 13th of February.
Item 17, CMP 627 of 2024.
Yes.
The last opinion, it was directed to file a substitute because it's for
respondent number 3 has died lost, IE has been filed for this substitution loss. And so far as respondent number 5 is concerned, loss, notices were served. But the SR report which says loss, the respondent number 5 has also died. So need to file a substitution petition for the respondent number 5. And for respondent number 3, I have already filed. And 2 and 4, loss, the service is affected.
Who is respondent? Which idea is for respondent?
The IA number 1380.
When did he die?
Let's only when they died on 30th/8/2015. In second paragraph, I have mentioned.
This is arising out of second appeal. Second appeal number.
But the second appeal 470/2017.
So at the time of second appeal, he had already expired.
We didn't have the knowledge regarding that. Because when the notices were served, during that time, the SR reports.
You were the appellant or the respondent before the first appellate court?
Where is that?
You were the appellant. And he was the respondent.
We were the plaintiff, appellant on.
So a petition for substitution would be maintained.
Because we didn't have the knowledge about the whereabouts of the and plus his existence. So ultimately, when the notices were directed to this, during that time, from the SR report, we came to know that that person is known. And so far as the respondent number 5 is concerned, also from the SR only, today only I came to know that the respondent number 5 has died in the year 2020.
Where are the details of the legal news?
The details is in paragraph 3. In paragraph 3, I have
Just a moment. IA number 1310/25 and CAP number 627 of 20. Counsel for the appellant submits that the CAP arises for restoration of second appeal number 470 of 2017. He submits that notice was issued in CMP. CMP में notice हुआ था in CMP, and it has been reported that respondent number 3 or opposite party number 3?
Opposite party.
Namely Ramesh Mehta,
CMP has in the opposite party.
who has died on 30/8/2015, that is much before filing of the second appeal. He has filed a petition seeking substitution. However, the consequence of non-substitution of respondent number 3 is yet to be examined. Let notice be issued to the proposed legal heirs and successors of Ramesh Mehta, whose details have been mentioned in paragraph 3 of the interlocutory application. Through speed post, for which requisites be filed by next Friday of entry. Office to track speed post delivery. Post on 30th of January. और दूसरा क्या है?
Opposite party number 5 he has also died, so therefore notice will not be affected. इसके लिए we will be requiring permission to file an IA for substitution. From the office.
As per office note, Opposite party number 5 has been reported dead. डेट दिए ना आपका, कौन सा डेट दिए? 30. You are for legal aid agencies?
State.
For the state?
Yes.
You are a legal aid counsel also, no?
Yes.
Item 18, second of bill 42 of 2025.
Yes.
On 7th January, they have filed 2 applications. Blood response is necessary. I will file this bill.
It's a number 42 of 2025. There are so many IAs. You want to file response to all the IAs?
Two. Whether on
IA
7th
number?
IA number is not in my.
The 4 IA pending.
On 7th January 2026.
Petition has been filed.
IA number तो बताएंगे ना? Counsel for the parties are present. Parties are service complete है? Service complete है?
कुछ लोग appeared हैं, कुछ लोग
तो
appeared
बताइए ना कौन appeared है? Service is complete, not complete. फिर अगला डेट में उनको फिर fresh steps. 6 महीना का कहानी मत सुनाइए उनको. आप हमको बताइए कि किसको fresh notice करना है, किसका डेथ हो गया है, किसका substitution है.
सब्स्टिट्यूशन का ही हम लोग का 6, 10 और 12 का हम लोग फाइल किया है, उसका लिमिटेशन भी आज बोर्ड पर है.
Respondent number 6, 7, 10 and 11. They have been reported dead.
7, 11 को हम लोग already 7
Delete
डिलीट करा चुके.
7, 11. So substitution
6,
of
10 और 12 का सब्स्टिट्यूशन और
6, 10 and 12.
उसका हम लोग एक फाइल किया है.
IA number?
एक आईए नंबर 11,024 और उसका आज लिमिटेशन पिटीशन भी साथ में
11024 and 16108. Yeah?
127. 26. Stipul that is first.
That is for stay of execution.
You just tell us कौन से IA का आपको response करना है बताइए ना.
127.
Actually, difficulty is that they have filed IA in IA. So this is the difficulty.
IA in IA?
Yes, I got it. IA, my lord, kindly have a look to IA number 127 of 2026.
SA number 42 of 2025. Counsel for the parties are present. How much part-time do you need?
My lord, only 3 weeks, my lord.
3 weeks.
Yes. Parties are resident of Sahibganj.
So 3 अप्रैल का यहाँ.
अनिल ठंडा बहुत है यहाँ पर. Lady है सच्ची रानी देवी.
Counsel for the respondent prays for and is allowed time till 30th of January 2026 to file reply to the interlocutory application, failing which no further time will be given. Reply if any by 6th February. Post on 13th. सारा आईए का कॉपी ले लीजिए. ये मत बोलिएगा कि मेरे पास सब आईए का कॉपी नहीं है. आप जितना 4 आईए पेंडिंग है, please provide them with a copy of all the IAs. 4 आईए आपके पास है कि नहीं? आप लोग साथ में बैठ के देख लीजिए ना.
Item 19, Civil Review 118 of 2025.
Yes, appellant.
Last year the notice has been served, but as per the office not been received. Now we have received the information that the respondent has been died on 2/6/2025.
From where did you get this information?
From the petitioner owner, from the applicant owner, we have to confirm and then we will file substitution.
Civil Review number 118 of 2025. Counsel for the petitioner submits that sole respondent has expired on 2/6/25. However, as per office note, Nibasant nahi likhi. Apparently, the proceeding has abated. However, she seeks adjournment. Kab rag dein?
After 2 weeks.
Post on 30th of January.
Item 20, FA1 30 of 2025.
Ballot IA number 4734 of the court for continuation of delay of 43 days. There was earlier order to file Talatama.
Let's say I filed my wakalatnama on behalf of respondent number 1. With respect to respondent number 2 and 3, they are the marriage sisters of respondent number 1. I have their present and correct address matter.
Provided to me.
Yes.
Speaking. FA number 130.
Yes, ma'am.
130 of 2025. Mr. Your name please.
Siddharth Jain.
Mr. Siddharth Jain appears and submits that he has filed wakalatnama on behalf of respondent number 1 and undertakes to give the present and correct address of respondent number 2 and 3 to the learned counsel for the appellant during the course of the day. Let notice be issued to the respondent number 2 and 3 at their present and correct address. For which requisites under speed post be filed by next Friday. Office to track speed post delivery post on 30th of January. Requisites in litigation matter.
Requisite in IO.
In IO, only in IO.
Item 21, Civil Levy 157 of 2025.
Yes, please.
Lordship, this review application is filed for review of order dated 28th January.
Order dated?
Order dated 28th January 2025 and except to page 24, my lord. There is delay of 2 to 4 days, my lord.
अच्छा मैकेनिकली हम नोटिस नहीं करेंगे पहले बताइए क्या है आपके रिव्यू
My lord, इसमें my lord order was passed, my lord, and this matter has originated from the labor tribunal. Thereafter, this.
You show me that what is the error apparent on the face of the record. You are filing a review of a contempt order.
My lord. No, my lord. I have record. I have filed this petition in the circumstances.
I want to know which is that order in connection with which review has been filed. Next page number?
Page number 24.
Page number 24. That is an order passed in a contempt case.
Contempt case.
Show me that what is the error in the order.
The error did not at all say that it is error. The position is, my lord. I have to go to a head directed to go to the labor side and get it executed. The order will be implemented by the court who has passed the original order. And the situation is, my lord, from 4.5 years, there is no court, available court in the state, my lord. I tried my best to get the
all the labor courts in the state have become defunct.
My lord.
All the labor courts.
No, labor tribunal.
Labor tribunal.
Labor tribunal of the state where the site will be filed, my lord. And more than 4.5 years, there is no presiding officer, and the entire matters are pending there, my lord.
So therefore, you cannot be a ground for it.
My lord.
You file your appropriate petition for ensuring that the labor tribunal becomes functional. But in this particular review application, I cannot entertain it.
My lord, review application, other point, my lord, in all similarly situated matters, my lord.
We will not bother about it.
Annex of-
Contempt petition, we are not going to entertain.
My lord, I know, my lord, this is discretionary, my lord, but this is not a bar, my lord.
No, no.
And petitioners are suffering from 2000.
You
my
have
lord.
taken wrong steps. This is not the correct step.
My lord, what I have to do, my lord, please.
I do not know, I am not your advisor. देखिए, civil review number 157 of 2025. This petition has been filed for review of order dated 28/1/2025, read with WPL number 209 of 2023, dated, order dated 17/5/2023. सबका एलपीए सब मिला दिए हैं, इसलिए ये किस तरह का प्रोसीजर है आपका सिविल रिव्यू? एलपीए का ऑर्डर बेसी में है।
My lord, LPA इसमें फाइल हुआ था, my
बहुत
lord.
अच्छी बात।
LPA के बाद रेमिट हुआ था या मान हुआ था.
LPA number 498 of 2019, in bracket order dated 24/11/2022 and award dated 25/10/20. The learned counsel for the petitioner has submitted that in contempt case civil number 821 of 2023, it has been observed that it was for the petitioners to get the award executed through the process of law as provided under Industrial Disputes Act 1947. He has submitted that the industrial tribunal is non-functional for 4.5 years. And therefore he is seeking, he has filed this review petition. This court is of the view that such ground cannot be a ground for seeking a review of the order. IA number 15163 of 25 in this case has been filed for condonation of delay of 224 days in filing this civil review application. It has been mentioned therein that
Paragraph 5.
the civil review application has been filed for restoration of contempt civil application number 821 of 2023 so as to get the fruits of the order passed by this court. And there has been delay in filing this petition as the
Paragraph 6.
as the industrial tribunal is non-functional for 4.5 years. Since on merits, this court finds no merit, this court is not inclined to entertain this review application. The petition for condonation of delay is also dismissed.
Item 22, CMP 921 of 2025.
Yes.
Saying this short respondent, the petition application was to be filed.
Who died when?
The sole respondent died on 1/5/2019. That was brought on the court by the respondent himself, by the
CMP number 921 of 2025. It has been recorded in by IU number 16412 of 25 dated 4/12/2025. It was brought to the notice of the respondent that the sole respondent has expired on 1/5/2019. This fact was also mentioned in order dated 5/12/2025. However, no petition for substitution has been filed. Counsel for the appellant seeks adjournment. By way of last indulgence, the matter is directed to be posted on 13th of April.
Item 23, CMP 1108 of 2025.
On the last occasion, notices were issued in both the CMP as well as in IN as per office report village. Respondent number 1 for it is showing delivered, 2 and 3 undelivered, 4 is delivered, and Vakalatnama is also present for the counsel of respondent number 1 only.
CMP number 1108 of 2025, counsel for the petitioner, prays for time. As per the office note, OP number 1 and 4 have been served. Counsel for the appellant is directed to take fresh steps for service of notice through speed post upon opposite party number 2 and 3 in the main CMP as well as in the interlocutory application seeking condonation of delay by at the present and correct address by 30th of January 2026 or to file an appropriate petition seeking substituted service of notice credited.
I pray that the returned notices may be utilized for revision.
It's not annexed with this, I do not know where it is.
Obligation.
Just a moment. Post on 13th of February. If this order is complied, post on 13th of February.
For admission, item 24.
There is a preemptory order, take care.
For admission, item 24, CMP 318 of 2007.
Yes, sir. अब आपका क्या क्या बचा है?
मेरा इनका वकालतनामा फाइल करना था
करनी।
I have to file वकालतनामा on behalf of OP number 3 to OP number 38C.
3 to
38C.
38C.
One.
The CMP number 318 of 2007. Counsel for the Mr. Ashok. Sorry? Mr. Rakesh Kumar Sinha. Prays for adjournment to file Vakalatnama on behalf of respondent number 3 to 38 with bracket C. Post on next Friday.
OP होगा.
OP.
Item 25, CMP 842 of 2022.
Kindly have order dated 7/11/25, that is order number 8. Para 5 and kindly be seen. The issue was pleased to direct the concerned DLSA to approach the OP number 1, against whom this CMP has been filed for execution of the leadership's order that had condoned the delay and payment of 1,50,000 was to be given. Now, consequently, I have perused the office records. Finally, have flag A and flag B. Those are letters written by the concerned member secretary to the secretary and consequently to the from the secretary.
No response?
No, they have approached. They have approached. He has sworn an affidavit also.
Nimai Ghosh.
Yes.
Yes. What is
Para
this
4,
affidavit?
para 4 of that affidavit we received.
Yes.
He is given his no objection on affidavit. He has also executed a wakalatnama in favor of anyone who the legal services authority
That I
chooses to.
state that I have no objection if the amount of rupees 1,50,000 is directed to be revalidated.
If your ladyship remembers,
The demand draft and redeposited by me before the Jharkhand High Court.
if your ladyship
So
recollects,
where is the
with the
demand
registrar,
draft?
with the registrar.
So who will revalidate it?
Yes. So if your ladyship recollects, he had written a letter directly to this honorable court.
Yes.
After which your ladyship had passed this order 7/11/25.
That's
Thereafter, there was a direction to the concerned DLS. Now he has executed an affidavit. He has sworn an affidavit and executed a wakalatnama. So here's what I am proposing.
He has executed a wakalatnama?
Yes, he has executed a wakalatnama. It is part of flag.
वकालतनामा से किसी के फेवर में वकालतनामा
हाँ किसी के that is there. In fact, I think there are two wakalatnamas.
फोटोकॉपी वकालतनामा
One of them is original, I believe. There is one in which there is a tick mark. I think that one is the original.
anyway इसका तो कुछ हो नहीं सकता
So any concerned officer of the, in fact, how the DLSA ought to have proceeded with all respect is simply gone ahead and executed a wakalatnama in favor of a person who is appointed by the DLSA. So then this whole process would not have been repeated. Now again the same thing, the concerned DLSA will have to again go get a wakalatnama executed and then initiate process of revalidation of demand draft.
कहाँ का डिमांड ड्राफ्ट?
Sorry?
कहाँ का डिमांड ड्राफ्ट?
Jamshedpur.
On the basis of this affidavit, can we ask the DLSA to get the demand draft revalidated?
It is on the basis of the letters given by the DLSA. The DLSA has also written letters, many letters,
Okay.
between the member secretary and the secretary. So that communication is enough. Plus there is a direct letter to address to the leadership.
डिमांड ड्राफ्ट है ना,
Yes.
उससे आपको पैसा चाहिए,
Yes.
बैंक एनकैश करेगा?
You to revalidate होना पड़ेगा.
जब तक वो नहीं होगा तब तक कोई काम का नहीं है. It's a scrap of paper.
So here's
The
what I'm.
point is who will get it revalidated?
Yes, the DLSA now. The DLSA ought to. That is what your ladyship decision was. That is what your
Yes.
ladyship's order was, which is I was inviting your ladyship's attention to para 5.
That's
Your ladyship had said the concerned DLSA should approach the OP number 1 and
get it revalidated.
yes, get it revalidated and start the process, whatever is there. Instead of that, an affidavit has been sworn and a wakalatnama has been executed. And that empty wakalatnama has now been annexed as flag A and B also. So that serves no one's purpose. And in fact, it doesn't serve the cause of OP number 1 also, who has said that he
You
has
don't
no.
fill the wakalatnama and appoint a person.
Yes, so the DLSA has to be directed to make amends and issue it correctly to get a person.
We'll ask the demand draft to be sent to the concerned district legal services authority.
To get it
and
revalidated.
They will get it revalidated.
Yes, yes. Only
That is the only
request. Only request is that a time schedule may be provided in
There
addition,
has to be a time.
because otherwise this will continue.
देखिए, CMP number 842 of 2022. The learned counsel for the petitioner has drawn the attention of this court to order dated 7/11/2025. Appropriate steps have been taken by the DLSA as is apparent from the record. The learned counsel has drawn the attention of this court with respect to the affidavit which has been placed on record executed by Nimai Ghosh, whose contents are as follows. इसको quote कर देंगे इस affidavit को. The learned counsel submits that the demand draft is lying with the registrar general. And the appropriate order be passed so that the demand draft is sent to the secretary DLSA so that the demand draft is revalidated from the concerned bank
Through the DLSA.
through the DLSA. If there is any अपने ही पूछ लेंगे वो उस बंदे से निमाई से कुछ भी पूछ सकते हैं ना.
Affidavit was enough.
That's it.
Affidavit
It
के
is-
बाद they should have simply gone ahead and get it in.
Anyways, it doesn't. The learned Registrar General is directed to send the demand draft. Demand draft number क्या है?
It's not there in the order.
Which has been deposited in
That is before the Registrar General Jharkhand. This is by order dated 18/5/2019. Passed in FA number
18/5/2019.
Passed in FA number 51
Number 51
of 1999 brackets R.
1999 bracket R. Deposited before the learned Registrar General pursuant to order dated 18/5/2019, passed in FA number 51 of 1999 within bracket R.
This is can I just pass on the order also? Two IAs in this, so that is why it's for clarification.
Through special message. Upon receipt of the demand draft, the Secretary DLSA shall do the needful so that the demand draft is revalidated and is sent back to this court.
Because the OP number one will have to revalidate it. The DLSA cannot revalidate his demand.
To get it revalidated.
That is why they will need the consent and
Appropriate
the
steps
power
to
of
get it revalidated.
some schedule may be given.
ठीक है, वहाँ भेज दीजिए उसको. Was this case on 13th February?
Let a time schedule be given to the
13th
DLSA.
February. काफी?
No, a time schedule to the concerned DLSA to finish the entire procedure.
वो 13th February काफी होता है. It will come by that. तो immediately send कर देंगे. डेढ़ लाख के पीछे कितना परेशान है.
Item 26, Contempt Bill 266 of 2023.
Jharkhand University has received the amount from Ranchi University, which was to be paid in favor of the petitioner. Through check we have received it, and it will be paid to the petitioner.
How much amount have you
Lordship,
received?
the amount is 7,800.
Only 7,000.
Yes, Lordship.
इसके लिए इतना दिन से कहानी चल रहा है?
क्या होगा?
7,000.
This is the amount, Lordship, which we have received from the Ranchi University. Yes, sir.
Admissible amount.
ये this petitioner's great husband was posted as lecturer, but his promotion has been given by notification dated
इसका you are for the state?
No, I'm 25.
Where is who's for the state? Leadership and for the state.
Since 91.
This is registrar Ranchi University, right? You are for Ranchi University. इसका breakup दीजिए calculation. Give us the breakup.
Promotion का
As per the various claims we have received from the college, we have paid.
This is the claim that you have received from the college.
Yes.
You just annex the claim and the calculation. ठीक है? जरा देखें तो सही ये 7,000 रुपए का calculation आप कहाँ से लेके आए? हाँ? These people is fighting for 7,000 rupees.
24/9/25 fixation हुआ है 10,000 के पेज हाँ तो पेज में डिफरेंस आएगा ना
Difference आएगा ना भाई. पूरा calculation देखते हैं. 2 + 2 4 की है कि 2 + 2 - 2 की है? ऐसा हो सकता है? I don't disbelieve this. 2 + 2 can be -4 in that. कि 2 रुपए नहीं दिए तो माइनस. हाँ? बताइए how serious it is. You give the calculation. कॉलेज कौन है इसमें? आपको कॉलेज से भी जो मिला होगा कैलकुलेशन वो भी देंगे इसमें. You should annex that. Contempt case civil number 266 of 2023. The learned counsel for Kolhan University has submitted that a check of rupees 7,800 has been received from the Ranchi University, which will be remitted to the account of the petitioner at the earliest. Council for the Rajini University has produced a copy of the communication dated 17/12/2025. Council for the Rajini University is directed to place the communication, a copy of the check and also a calculation on the basis of which the amount has been alleged. How much time do you need? ये 3 पन्ना आपको
3
लगाना है. 3 weeks. 3 pages के लिए 3 weeks. You have to just put 3 pages.
2 weeks.
एरिया ऑफ सैलरी एरिया ऑफ पेंशन साथ
ये लेटर का कॉपी इनको दे देंगे. यही आने वाला है, आप देख लीजिए. इसको लगा, इसमें बांध देंगे. Post on 28th January, the affidavit should be filed latest by 27th.
Thank you. Item 27, contemptuous level 69 of 2023.
The sensitive point of the stress has been dismissed now, 6th of January 2021. जो 3 हफ्ता का टाइम दिया है
अब कोई हफ्ता आपके टाइम
कंप्लायंस के लिए
कंप्लायंस नहीं 3 हफ्ते का क्यों टाइम
कंप्लायंस के लिए टाइम
नहीं. आपका कंप्लायंस रिपोर्ट आना चाहिए.
नहीं तो हम टाइम उसी के लिए ब्रेक करें.
बिजनेस कब हुआ?
6th of January 2026.
अच्छा, किस ऑर्डर के अगेंस्ट में गए?
Yeah.
This order is dated 22nd November 2022. It is annexed at Annexure 1, page 70.
22nd November ने किस ऑर्डर के अगेंस्ट में आप गए थे?
That is the order of the SBA matter, which was dismissed on 4th of July 2025.
What was the nature of order?
It was dismissed on delay. The writ order was issued.
How much is the calculation? Tentative. आपने इनको बहुत तंग किया. आप चेक करके आइए. You have your account number? You provide us the account details. बस आप क्रेडिट करके आइए.
जी.
डे टू डे फिक्स कर देंगे. जितना आप तंग किए ना इनको, उतना तंग हम आपको एकदम इक्वल फुटिंग. तो आज फ्राइडे है, कल आप क्रेडिट करिए, मंडे पर.
नेक्स्ट फ्राइडे लौट रखा जाए. आई विल ट्राई टू इंश्योर कि पेमेंट हो जाए.
ठीक है. डॉक्टर प्रोफेसर अरुण कुमार, ये है ना नाम इनका?
जी.
कंटेम्प्ट केस सिविल नंबर 669 of 2023. The learned counsel for the opposite party has submitted that the SLP has been dismissed. SLP filed against LPA number 235 of 2025 has been dismissed. He has been instructed to submit that the amount will be calculated and shortly remitted.
ये इंस्ट्रक्शन तो नहीं है, हम खुद से बोलेंगे.
The learned counsel has submitted that it appears that he has no option but to calculate the amount and remit it to the account of the petitioner. ये तो सही है ना?
हाँ.
ठीक. Counsel for the petitioner has provided the bank account details of the petitioner. आप हमको फोन पे लेकर मैसेज ठीक से लेकर फॉरवर्ड करेंगे. एक भी डिजिट एरर नहीं होना चाहिए. ठीक है? ये तो चला जाएगा पड़ोसी के अकाउंट. Right? Close this case on next Friday.
अच्छा, इनका पेंशन वाला क्रेडिट हो रहा होगा तो डिटेल होगा.
कोई बात नहीं.
उसी में वो क्रेडिट हो गया.
Item 28.
Take second. It appears that the petitioner is already receiving pension.
हाँ वो 61 years of age है तो
छोड़ दीजिए, आप बता दीजिए ना अकाउंट.
वो उसी अकाउंट में क्रेडिट हो जाएगा.
जरूरत नहीं है.
नहीं जरूरत नहीं है.
जरूरत नहीं, मत दीजिए इनका अकाउंट. फ्राइडे को बात करें.
हाँ फ्राइडे को, नेक्स्ट फ्राइडे को अकाउंट.
सप्लीमेंट्री लिस्ट निकालिए.
जी.
Item 28, Contempt Civil 915 of 2023.
ये फाइल तो डिट से भी मोटा हो गया, क्या चक्कर है?
से हो गया है. The order has been complied, but apart from a litigation which is fighting here, the petitioner, I am not saying about the council.
अरे काउंसिल की तो कोई बात ही नहीं करते हम लोग.
अब ये petitioner जो है, he is fighting another litigation outside the court, making allegations about his own counsel, about the government counsel, about the intervener counsel. This is the allegation level that all of us have connived against him.
कोई बात नहीं, उनको वीडियो दिखाइए, कोर्ट का वीडियो. एनीवेज आप तो ड्रॉप कर देना प्रोसीडिंग.
Yes, as per report of the CEO, Your Lordship, the petitioner pray for demarcation of total land
आपका हो गया ना जो होना था.
नहीं हो गया है, उसमें 2 एकड़ 65 डिसमिल हमको दिखा रहे हैं कि मेरा जमीन पड़ती है, और 3 एकड़ 30 डिसमिल
आपका कितना हुआ मतलब नहीं है.
हाँ वो कर
कंटेंट ऑफ कंटेंट के सिविल
915 कोट किया जाए, कर दिया जाए. इसमें नहीं कर.
The learned counsel for the opposite party has referred to paragraph number 11 of the show cause dated
10 and 11, दो पैर.
10 and 11
10
of
is,
show cause dated 6/1/26, which is quoted as under. The learned counsel submits that the order of this court has been substantially complied. 10 and 11. The learned counsel for the petitioner has submitted that in view of the aforesaid, आपका submission नहीं लिखा. In view of the aforesaid assertions in the show cause, this court is not inclined to proceed any further in this kind of proceedings with this hereby court. क्या पता टाइटल सूट फाइल करेंगे, क्या करेंगे, इसलिए आप
तो डिमार्केशन का बात है, टाइटल थोड़ी ना ट्रांसफर हो रहा है.
Item 29, Contempt
मतलब
Civil.
कुछ भी आपका क्लाइंट, आपका लिटिगेंट आपके कंट्रोल में नहीं रहता.
नहीं, actually my client has already
taken no objection
before this court, Your Lordship, and he said, Your Lordship, he never made any application against our lawyers, against the counsel of the other sides. He has clearly said that one affidavit has also filed before this court, Your Lordship, regarding the false claim, Your Lordship.
Item 29, Contempt Civil 985 of 2023.
This contempt petition may kindly be disposed of, my lord, in view of the order passed by the IG registration on 11/11/2025. But with liberty, my lord, to challenge or raise the grievances, my lord, which survives, my lord, because at page 47, my lord, the IG registration has held that they have conducted the inquiry in compliance of the order passed by this honorable court. But the action taken against the society, my lord, and within 15 days, the society concerned, my lord, who has committed the financial irregularity, my lord, that grievances has yet to be redressed, but for that there is a fresh remedy is required. So, my lord, with liberty to raise the appropriate problem.
आप इतना जूनियर को ऐसे क्यों डालें?
नहीं जूनियर को नहीं, हम बोल रहे हैं कि जब हम ये कर रहे हैं तो इट्स ए प्रिविलेज, इसको सिखा रहे हैं जो कि पहले पेटिशनर का राइट बनता है. नहीं, इसको 2-3 बार हम देख चुके हैं, इसीलिए हम बोल रहे हैं कि दिस इज फर्स्ट प्रिविलेज टू द पेटिशनर, देन ही हैज टू रिस्पॉन्ड.
वो तो पेटिशनर है, अपोजिट पार्टी की बात है.
अपोजिट पार्टी ही है, तो पहले राइट पेटिशनर को
जैसा है ना, छोटा सा बच्चा.
इसलिए हम इसको आस्ते से विथ ऑल काइंड ऑफ अथॉरिटी हमने इसको बोला कि पहले पेटिशनर बनाना. तो पेटिशनर को पहले जो एक राइट टू ये होता है, एडवोकेट जनरल रहता तब तो फिर इससे अलग बात. लेकिन यहाँ पे ऐसे होता है तो पहला राइट पिटिशनर को ही जाता है।
जब एक बार कंटेंट में नोटिस इशू हो जाता है ना, तो ऑपोजिट पार्टी को बहुत राइट हो जाता है,
राइट हो जाता है टू डिफेंड, बट हम जब उसको मैटर को खींचते हैं, हम तो वेरी आउटराइटली आई एम सबमिटिंग दिस।
इतना बोलने का उसको मौका मिलना चाहिए ना।
हाँ, आप बोले ना, आप बोले।
My lord, we have filed the third so cause. In para 18, we have mentioned that we have, my lord, we have passed the reason order, and order has been complied, passed by this honorable court. And earlier they have taken the time to file the response to this third so cause.
Contempt case civil number 985 of 2023. Counsel for the opposite party has referred to the third show cause filed on behalf of opposite party number 2 and has referred to paragraph 18 of the same to submit that the order, a reason order has been passed in compliance of the order dated 25/4/2023 passed in WPC number 1546 of 2023. At this, the learned counsel for the petitioner submits that the liberty be reserved with the petitioner to take steps as per. Considering the submissions, this court is not inclined to proceed any further in this contempt proceedings. Liberty is reserved with the petitioner to take steps as per.
Item 30, CMP 117 of 2024.
Yes. Restoration of writ petition.
Earlier,
It was dismissed for on what ground? Non-removal of defects.
and earlier in para 2, earlier it was allowed by the for renewal, but the defect also rest due to that in para 11 could not remove due to the calculation mistake of the code field in para 11 only.
So when an application for restoration has been disposed of by Honorable Justice Ananda Singh, how this fresh application can be filed?
Because of कि ये नहीं हो पाएगा
नहीं हो पाया तो आप उस CFP में आपको जो करना है वही कोर्ट में करेंगे, हम यहाँ से रेस्टोर नहीं करेंगे। एक बार CMP फाइल करने के बाद, in case something happens, you have to take steps in this CMP.
But CMP is not a tied up matter.
Sorry?
CMP matters are not in category of the tied up matters.
Res duty काटा नहीं लगेगा। तो मेरे पास क्यों है ये लिस्ट में आया? I will
Yes,
I will not say.
it was dismissed by the
तो ये क्या हुआ?
Annexure 2 देख लीजिए.
Annexure 1 पहले देखते हैं. What is Annexure 1?
Annexure 1 में allowable by the Honorable Mr. Sri Ananda.
Now, after this order also you are not removed the rules.
रिमूव किए थे 12-11 में लिख दिए जाए रूल मेंशन किए हैं कि सिर्फ कैलकुलेशन एक स्टाम्प का कैलकुलेशन मिस्टेक के कारण ये रह गई।
इसको हम रेस्टोर नहीं करेंगे, हम डिसमिस करेंगे। I will not restore this. इसका जो पुराना रेस्टोरेशन
only 75 रुपये का स्टाम्प शॉर्ट कर कैलकुलेशन मिस्टेक इसको काइंडली
नोट नहीं करेगा इसका एक तो CMP भी होगा तो आपका तो ये restoration तो एक बार अलाउ हो गया था ना earlier it was dismissed on account of non-compliance of my order.
Yes, ma'am.
Then the matter was placed before another bench, and in spite of it should have been a tied-up matter, correct? It should have been a tied-up matter.
Restoration.
Yes. The CMP number 981 of 23.
Yes, ma'am.
Should have been a tied-up matter. Yes. It should have been a tied-up matter or not? Because you just see the first line for restoration of WPS number 4744 of 2019, which was dismissed for non-compliance of order dated 18/10/22. 18/10/22 is my order.
Yes, ma'am.
But it has been restored by another bench. Fair enough. No problem. I will not take any offense to that. Had you pointed out to the court would not have passed it. Anyways, there is no problem. And then again that order has not been complied.
Complied, madam, but only the calculation mistake, the 75 rupees.
Complied means full compliance.
Madam, but due to the clerical
Compliance,
mistake,
no. Compliance means full compliance.
Yes,
Compliance.
इसमें बहुत सारे petitioners हैं,
That's
so
right.
that कि जोड़ने में mistake हो
Right.
गया था.
Then you file another petition for restoration.
Yes, this.
I will not entertain it.
This one, madam.
You file the petition before the same judge in connection with CMP number such and such. I will not entertain this.
तो उनके यहाँ इनको present कर दिया है.
उनके यहाँ तो नहीं जा सकता ना, क्योंकि अब जो ऑर्डर का रेस्टोरेशन आप फाइल कर रहे हैं वो मेरा ऑर्डर है.
Yes.
अब कैसे जाएगा?
इसको भी ड्रॉ कर लेते हैं.
CMP number 117 of 2024. Counsel for the petitioner seeks permission to withdraw this petition. Accordingly, this petition is dismissed.
सर साइन कर दीजिए.
Item 21, CMP 201 of 2024.
This CMP is for the restoration of the petition, which will be DT on 7/7/2022 on non-prosecution.
Non-prosecution or non-compliance of order?
Non-prosecution notice, because the advocate has not appeared. Paragraph number 4, there is 523 days delay.
No, it's not a matter of delay, it's a writ petition, no?
Yeah, originally, the petition of writ petition, there was a writ petition which was filed for direction from this court. For the direction from
No,
this
we have
court.
seen the order. We have seen that order.
Lordship.
Order of non-prosecution, because nobody entered evidence ultimately.
Lordship.
In spite of getting no objections.
In spite of that.
Because it was submitted that there are no instructions. And this one counsel has given no objection in the case of this.
Due to the fact that this petitioner has suffered COVID, very acute COVID problem, that's why he could not be able to.
Petitioner need not come to the court. The counsel has to come to the court.
The counsel, earlier counsel, okay, has given NOC which was not communicated.
NOC तो litigant को दिया जाता है ना? किसको दे देंगे NOC? The litigant would come and take the NOC, isn't it? Then NOC was given. It means that the litigant had come to take the NOC. So.
Yes, sir. Yes, he might have come.
NOC taken.
NOC taken.
Fresh Pakalatama not filed. The case was dismissed for non-prosecution. So what is your ground for restoration?
Restoration also only this is only this is the ground, right?
Sorry?
He was not appear due to the fact that he was not that might be wrong. But after that he was suffering, he suffered on 2021 COVID, due to which he was not able to get in touch.
What is this High Court seeks probe status from CBI by 4th of March? What is it?
In original petition, as for the advertisement number 1 of 2007, there are many cases has been filed and the matter was directed and taken up by the CBI. So that report was made. Such matters, and one of the batch matters was dismissed by Honorable Mr. Deepak Roshan for lecture. And 2 such matters are also pending. Single matters.
बिना cost share restore नहीं करेंगे. How much cost do you want for the clerks association?
5,000.
CMP number 2001 of 2024. This petition has been filed for restoration of WPS number 1060/2011, which was dismissed for non-prosecution on 7/7/2025. The learned counsel for the petitioner submits that the petitioner suffered serious medical condition and therefore appropriate step could not be taken for filing fresh matter. And ultimately, on account of absence of counsel or the petitioner himself, the writ petition was dismissed for non-prosecution. किसी को नोटिस हुआ इसमें? रीच में तो इतने सारे पार्टीज थे, आपने किसको किसको पार्टी बना दिया इसमें?
मतलब एक इसमें हमने फिर एडिशनल पार्टी ऐड किया नेक्स्ट पेज पे।
ऐसे से थोड़ी होता है।
केसेस कॉज ऑफ एक्शन को
नहीं नहीं, ये तो रीच में तो बहुत सारे पार्टीज थे।
तो हमें इसमें पेज में हमने एडिशनल पार्टीज को ऐड किया।
कहाँ ऐड किया? Where have you added? ये पीछे। Issue notice to the opposite party member. CBI भी पार्टी है इसमें। CBI के लिए कोई अपील करते हैं यहाँ?
Maybe should be done at ASCI
to the opposite party number 5 to 11. Through speed post for which requisites be filed within 1 week. आप लेंगे CBI की तरफ से?
I will inform you. We are CBC. And that is particularly
यहाँ से 12 भी इंक्लूड कर दीजिए। The opposite party number 1 to 5 are represented by the councils. Post on 13th of February. Office to tax post delivery 1 week में फाइल कर दिया। 2007 का एडवर्टाइजमेंट अभी तक चल रहा है।
कुछ केसेस में चल रहा है, 2 केसेस।
Item 32 contains Bill 296 of 2024.
Last order, the show-cause has been filed on behalf of the Management Reviews Unit Corporation, and the show-cause has been filed on 5th of December 2026. Initially, the
5th of December 26.
5th of 5th of January 25. 5th of January 26. 5th of January 26 को हमने show-cause has been filed, and in show-cause the second last page of the show-cause may be perused. That is the page number 11. The page number 11 is a list of 16 workmen, and page number 12 is a list of 25 workmen.
There is no page number. Yes.
Yeah, totaling 41, 30, 41.
तो
41 का इन्होंने पेमेंट कर दिया। ऑर्डर था 71 को देने का, तो पार्ट कंप्लायंस अभी हुआ है, आधा बचा हुआ है।
लॉर्डशिप, हमने इनसे सारे डिटेल्स मांगे थे विद रिगार्ड टू द वर्कमैन हु आर अवेलेबल, जिनके पेमेंट्स इनको देने थे। 60 लोगों के आए थे हमारे पास डिटेल्स, आउट ऑफ विच 44 वेर एलिजिबल। वी हैव पेड 41, 3 के सक्सेशन सर्टिफिकेट के रिक्वायरमेंट है बिकॉज दे आर नो मोर देयर, दे आर डिसीज्ड। सो वी आर रिक्वेस्टेड द कंसर्न पार्टी टू प्रोवाइड अस द सक्सेशन सर्टिफिकेट, एंड अकॉर्डिंगली वी विल डिस्पोज ऑफ दैट आल्सो।
61 लोगों का ही नाम दिया था।
नहीं,
71 का दिया
तो जजमेंट में
अच्छा,
लिस्ट
71 का था।
जी, इन्होंने प्रोवाइड हमें जो प्रोवाइड किया वो क्या सारे डिटेल्स वो 60 के थे। वी हैव रिक्वेस्टेड
नहीं, हम उस चीज को डिस्प्यूट करेंगे, बोल रहे हैं 60 का, तो टोटल लिस्ट में जजमेंट में 71 आदमी
आप
को
डिटेल
देना
दे
है।
दीजिए ना यहाँ पर आपको जिसका
तो
देना है।
हम
Right
clear कर-
affidavit?
जी।
ये सब
जो
दे दिए
remaining-
थे और
जो
नहीं
re-
दिए थे, कौन यहाँ पे बैठे थे?
जी योर लॉर्डशिप जो रिमेनिंग है हम एक एफिडेविट फाइल करें।
रिमेनिंग वर्कमैन का।
जी रिमेनिंग।
और अगर उनका कोई लीगल ईयर है तो सक्सेशन सर्टिफिकेट लगा के फाइल करेंगे। ठीक है? Content Civil 296 of 24. Counsel for the petitioner submits that the order of this court has been partly complied. With respect to how many persons?
With respect to 41 power.
41 persons out of total
71.
71.
30 are still remaining.
The learned counsel prays for time to file an affidavit with regard to the details of the remaining workmen, along with their Aadhaar card. How much time?
March.
Post on 13th March.
Item 33 contains you 380 of 2024.
University is processing the claim of the petitioner. Then I'm praying for further 2 weeks time to file complaint.
Okay. With whom have you talked? Opposite party number किससे बात की? Two has given you instructions.
So far,
Mr. MC Mehta. Who has given you this instruction that it is under process?
we have received the instruction from the university.
From the university. देखिए आपके पास जो बैठे हैं उनको पता है ना किसने दिया? You are first year. You are for the university. Who has given you instructions that it is under process? OP number 2.
Should pray for 2 weeks time. It doesn't just to file.
वो तो as a last interview हम देंगे, लेकिन नहीं होगा तो हम किसको पकड़ेंगे इसका बात सोच रहे हैं। OP number 2, right? Contempt case civil number 380 of 2024. The learned counsel for the university submits that the order of this court is in the process of being complied. He prays for 2 weeks time by way of last indulgence to file a compliance report. Post on 30th. The compliance report to be filed latest by 27th. Is there any monetary amount involved?
Direction is to pass a reason order and then to forward the claim to the state for prefecture.
Item 34 contains you 483 of 2024.
In this case, the order out of which this contemplation has been arising, that is Annexure 1, page 11, 28th of March 2020. The petitioner challenged the order of punishment in the writ petition but get to the plea of alternative remedy of appeal. Therefore, the order was passed by the court. Page 12 is the relevant part. Paragraph 7. Considering the aforesaid submission, this writ petition is disposed of with a liberty to the petitioner to avail the alternative remedy of appeal within a period of 2 months from today. And upon filing the appeal, the appellate authority shall decide the appeal on merits within a period of 6 months. Number, the appeal is memo of appeal is page 13. Page 13 order through speed post it was filed. Number, it remained pending for more than 6 months as time was granted by the Supreme Court. Then on 19/5/2020, 17/5/2022, this appeal was preferred. Then thereafter, Lordship kindly see on 24th of February 2023, Annexure 3, page 18, for the first time, the petitioner was informed that the विभागीय paragraph 3 मैडम reading विभागीय आदेश दिनांक इतना के आलोक में आपका वेतनमान that is with regard to the punishment order which was implemented, but they remained silent over the appeal. Then out of frustration, as it appears on General Annexure 4, page 19, is the reminder that you are requested to postpone the matter till disposal of the Departmental Appeal. That is dated 8/5/2023. It was followed by another reminder dated 13/3/2013, then 30th November 2013. In this way, reminder. No appeal, no disposal of the appeal. Then ultimately he filed the contempt appeal. Now, your Lordship may kindly see this so-called. So-called, why I am narrating the facts now? The so-called they have annexed not one letter of the appellant. I have already annexed not annexure A and B, which are not annexure 4 and 5 to the contempt application. Now they have at page 15 that on 8th of May 2023, out of frustration, the petitioner wrote a letter to the concerned respondent. मेरे द्वारा अवगत है आज विभागीय संयुक्त सचिव के समझ सारी वस्तु स्थिति को समझाते हुए अपना पक्ष रखा। मेरे द्वारा आवेदित है बात संख्या इतना अपीलीय प्राधिकार के समझ कोई अपील दायर नहीं किया। Out of frustration, he said that no appeal has been preferred. Whatever it may be, they could have not passed. He is not getting pension. Therefore, not out of frustration, after reminder, memo of appeal, everything, he did not tolerate the delay in disposal of the appeal, and ultimately he says that he does not want to pursue, and if he had not filed.
So what do we do about it?
No, they have not passed any order.
You say that no appeal has been preferred.
But it is not. It is their case.
Are you filing a response to this?
Yes, that is not.
This is your document.
Yes, that is the
Then
document.
you have really booked somebody. What do you think? It's very serious.
Yes, sir.
Somebody can pressurize you to write a letter like this.
That is the position.
You just dispute. You fix the
Now
response.
he was admitted in hospital.
बस आप hospital मत समझे.
ना हुजूर एक
आप इसका response फाइल करें.
हाँ कर दें. इसीलिए कर रहे हैं कि हॉस्पिटल में है 2 हफ्ता या 3 हफ्ता का टाइम दीजिए.
Case number contains civil 484 of 24. Counsel for the petitioner has referred to annexure D to the show cause.
Page 15.
At page 15, to submit that it has been stated in the show cause that the petitioner himself voluntarily requested that 20% deduction be made from his monthly pension and 25% deduction be made from his gratuity. And he had also made a declaration that he had not filed any appeal pursuant to the order passed by this court dated 28/3/2022, passed in WPS number 651 of 2013. The learned counsel prays for time to find a response to the show cause.
Yes.
The reply be filed by 23rd February, post on 27th.
Item 25, CMP 541 of 2024.
Lordship, restoration of the WPS. Dismissed as non-compliance of the order, Lordship, as the one defect was remained as defect number 5. Trace copy or type copy of page 1954 and 74 may be given. I will file
Any
within.
objection?
No.
CMP number 541 of 24, this petition has been filed for restoration of WPS number 5532 of 23, which was dismissed for non-removal of defects in terms of order dated 15/3/2024. In terms of order dated 28/2/2020, the learned counsel for the petitioner submits that due to inadvertence, some of the defects could not be removed. The counsel for the respondent has
one defect.
The learned counsel for the respondent has no objection so far as the prayer for restoration is concerned. Considering the submissions, the time for removal of defect in WPS number 408 of 23 granted by order dated 28/2/2024. इसमें WPS number होगा 5532 of 2023. Granted by order dated 28/2/2024 is extended till 30th of January. If the defects are removed within the extended time, office is directed to place the requisition before applicable date as well as dismissed.
Item 26, CRP 1089 of 2024.
Criminal division number 752 of 2022.
Why was it dismissed?
Lordship, the counsel of the petitioner, the father of the counsel of the petitioner was expired on that time.
I'll give you time for removal of defect.
So he is not able to inform the petitioner for removing defect.
There was a defect of surrender certificate also.
Yes, sir.
Must have been there.
Lordship, in this, the default non-compliance order dated is 17/2/24 and the deposit of court fees of rupees 180. But the office has not accepted the case.
What were the defects to be removed? What were the defects to be removed? बताइए क्या क्या डिफेक्ट था आपका रिमूव करने
यही लॉजिक पर ये 180 रुपीस का डिपॉजिट करना था कोर्ट फी
और डिफेक्ट नंबर 4 and 7 क्या क्या था डिफेक्ट नंबर 4 and 7? सरेंडर सर्टिफिकेट तो नहीं फाइल किए थे कि कर दिए यस बताइए आपका लिटिगेंट जेल में है कि जेल से बाहर है
यस सर बाहर है सर बाहर
सरेंडर सर्टिफिकेट फाइल नहीं किए नॉट टुडे करके क्या होगा आपका टाइम फॉर रिमूवल ऑफ डिफेक्ट हम 10 दिन दे देते हैं एक्सटेंड कर देते हैं फिर से डिसमिस हो जाएगा नहीं फाइल करिएगा सरेंडर सर्टिफिकेट फिर से डिसमिस हो जाएगा समझ गए क्या बोली कर देते हैं ओपीडी है कोई It was rising out of what? Division against what? (498A). बिना नोटिस के तो हम कुछ नहीं कर सकते criminal division number 732 of 2022. Issue notice to the opposite party number 2 through the concerned police station, for which recusals be filed by 16th of January 26th. Post this case on 6th of April. Limitation भी है इसमें? नहीं है ना?
Item 37, contemptible 1113 of 2024.
Contained civil 1113 of 24 comes for the petition against that order has been complied with immediately and he does not want to.
Certain communications with the petitioner want to bring before the department.
The learned counsel has submitted that a right to reserve with the petition to take steps as may be permissible under law. Counsel for the opposite party opposes the objection. Consider the process and this court is not inclined to proceed any further in this kind of proceedings. However, if the petitioner has any surviving demands, he may take steps as may.
Item 38, contemptible 46 of 2025.
Yes, please.
Compliance affidavit file कर दिया। Your lordship kindly see the contempt and addition annexure 1, page number 12. Your lordship, para 7.
Post on next slide. Next. Please, you have to hear it, no?
Yes.
Next.
Item 39, civil review 128 of 2025.
In this case, by order dated 28/11/2025, limitation has been unknown. In this case, our prayer for review of an order passed by the Supreme Court, that is 23rd January 2020. It relates to mere reference. Number of the matter can be settled not in Jhalsa. Both the parties do not are directed to appear before the Jhalsa. It can be settled. What happened? The land owned by the petitioner.
So why have you filed a review petition?
Because there is some.
Yes. Which is what is the error in the order?
Yes, there is. The lordship may kindly see. It is not an annexure 1, page 25. Page 27 is the petition under section 18(2)(b) of the old Act, 1894. That remained pending. When the matter remained pending
So
and
you are
ultimately.
agreed by the order, you file your appeal.
But your lordship may kindly say only one thing which I beg to clarify. This matter under the old Act, and in 2015, after the new Act came into force, then the matter has been referred under the new Act, that is annexure 2, page 35. Your lordship may kindly see. It is not the petitioner, it is the district land acquisition officer who preferred it under the Act 2013. So it is to be decided under the Act 2013.
No, this is not a ground.
This is the.
You file your appeal against.
Then your lordship may kindly see for a moment.
It is not a ground for review. It is not a ground for review.
But
if you are agreed by the order, you can challenge.
So far the order is concerned, your lordship.
It is a very technical issue under what provision, and I have passed an order on merits that
Yes,
this will be governed by whatever act. No.
Your lordship has been pleased to pass an order, paragraph 8, if your lordship may kindly see, after quoting the learned authority under the Act 2013, declined to interfere with the proceeding after lapse of more than 4 years.
That's right.
And on the ground that the provisions of new Act 2013 as stated above.
I have held that the reference under 2013 was not maintainable. It has to be decided under the old act. I am not
That
inclined to, no,
That
this
is
is not a
the,
problem.
that is the crux of the matter.
That is the
Because
crux of the matter. It is
if-
on merits. I have given a decision. If you are aggrieved, you go and file appeal against this. So
But
review
the
number
fact
128 of 2025. Council for the
fact
parties are
remains,
present.
it is governed by Act 2013
तो आप जानिए क्या करें?
on the apparently on the face of the record.
This petition has been filed for review of order dated 23/1/2025 passed by this court in FA number 196 of 2023. The learned counsel for the appellant has submitted that the application for reference
Yes.
was made prior to coming into force of 2013 Act,
But it was referred,
but it
kept
was
pending.
referred subsequently, and therefore he submits
Referred
that.
under the Act 2013 and Annexure 2.
Right. And he submits that the reference was made under the Act of 2013, and ultimately
The authority under the Act.
the council submits that it has been observed by this court that the reference under the Act of 2013 was not maintainable, and the judgment of the court was modified to the extent that it would be open to the appellant to proceed and take appropriate steps in terms of the Act of 1894. The learned counsel submits that the appeal was, the reference was to be decided under the Act of 2013 and not under the Act of 1894. Having gone through the order and the review dated 23/1/2025 passed in FA number 196 of 2023. This court is of the considered view that no ground for review is made out inasmuch as the
Liberty is preserved under 8
Just a
to
moment.
10. The right to 10. It's taken care of.
inasmuch as the application seeking reference was filed under the Act of during the subsistence of the Land Acquisition Act of 1894, and therefore this court has said that the same would be governed by the Act of 1894. This court is not inclined to review the impugned. No grounds for review has been made out. Accordingly, this review petition is hereby dismissed.
All right.